everyone, Jax West from Stephen Avery Project, Justice with Jax, and MAM Gossip. I just got the filing from the clerk that came in on the 16th. So I'm gonna read through this with all y'all. I will not be responding to any comments or anything while I do this. I haven't read this yet. I literally just got it. So, and I still have to pay them. I have to pay them like $9 and change for this. All right. So, here's what it looks like. If I can, it's kind of hard. That's email I got. Okay, so, dear Ms. Reif, who is the clerk of the Wisconsin Court of Appeals, enclosed for filing is the above matter are the original and 4 copies of the response in opposition to Avery's 4th petition to stay this appeal and remand this case to the circuit court. A copy of this response has been served by mail on counsel for defendant appellant. Sincerely, Lisa E.F. Comfer, Assistant Attorney General. Response in opposition to Avery's 4th petition to stay this appeal and remand this case to the circuit court. Introduction. Plaintiff respondent, State of Wisconsin, opposes defendant appellant Stephen A. Avery's 4th petition to again stay this appeal and remand the case to the circuit court for consideration of yet another new Wisconsin statute 974.06 motion alleging that the state violated Brady v. Maryland by allegedly failing to inform the defense that a Thomas Sowinski purportedly called law enforcement on November 5, 2005 to say he saw Bobby Dassey moving a car similar to the victim's car. The motion on its face shows that it was filed in violation of Wisconsin Statute 802.05, applicable here via Wisconsin Statute 809.84, because it was filed for an improper purpose and without a reasonable inquiry into its factual basis. Staying this appeal and remanding for the litigation of such a motion would result in further unnecessary delay and litigation. This appeal has been languishing for nearly 4 years now, due entirely to Avery's repeated requests to return to the circuit court to litigate procedurally barred claims that have had no factual support. It is reasonable to conclude at this point that he is not pursuing these claims in good faith, but is merely, quote, throwing the proverbial spaghetti at the wall to see what sticks, unquote, and delay resolution of this case. Indeed, Avery's new claim is not only unsupported by even a suggestion of corroborating evidence, but this claim is also mutually exclusive with many of the other claims Avery has pursued in the circuit court and on appeal. All of these allegations cannot be true. Avery's reckless disregard of the truth or falsehood of the allegations he is submitting to the courts alone should be reason enough to deny his petition for remand. Moreover, this case has now been fully briefed in this court for nearly a year and has been submitted to this court awaiting a decision for nearly 5 months. Remanding this case to the circuit court to again allow Avery to develop another entirely new constitutional claim is not necessary to decide this fully briefed and long submitted appeal. It would be inefficient and waste the courts and the parties considerable resources that have already been expended and further delay this appeal's resolution. If Avery wishes to pursue yet another claim, the appropriate course is to either wait until this appeal is concluded, conduct a reasonable investigation, and file a new Wisconsin Statute 974.06 motion, or dismiss this appeal so he can pursue it now. If Avery has a sufficient reason why his new claim could not be raised in any of his previous 6 motions and some facts to support it, then the claim will not be procedurally barred when this appeal is concluded. If not, the claim is unquestionably procedurally barred already, and another remand would serve only to further delay his litigation and add another incongruous claim to Avery's appellate brief. Avery has dragged this appeal out long enough. He should either dismiss this appeal, conduct a reasonable investigation into his new claim, and pursue it in the circuit court now, or this fully briefed, submitted, and year-stagnant appeal should proceed. Background. In 2007, a jury convicted Avery of first-degree intentional homicide for the murder of Teresa Halbach and for possession of a firearm as a felon. His direct appeal concluded when the Wisconsin Supreme Court denied his petition for review in 2011. In February 2013, Avery pro se filed a Wisconsin Statute 974.06 motion alleging that the state had interfered with his ability to confer with his attorneys, that the state impermissibly commented on his silence during closing argument, that he was deprived of a fair tribunal, and ineffective assistance of counsel. The circuit court appointed an attorney to investigate the claims and ultimately denied the motion without a hearing in November 2015. In June 2017, Avery filed the Wisconsin Statute 974.06 motion at issue in this appeal, alleging that a multitude of constitutional errors occurred in his prior proceedings. The circuit court denied his motion without a hearing on October 3, 2017. Avery then filed a motion to vacate judgment on October 6, 2017. He additionally filed a motion for reconsideration on October 23, 2017, followed by several supplements to that motion between October 31 and November 17, 2017. The circuit court denied all of these motions without a hearing on November 28, 2017. Avery filed a notice of appeal from the circuit court's final written order on November 30, 2017. On June 7, 2018, the court retained jurisdiction but remanded this case to the circuit court to allow Avery to file another Wisconsin Statute 974.06 motion to litigate a Brady claim. The circuit court denied that motion without a hearing as well, and the record was transmitted back to this court on September 28, 2018. On December 17, 2018, Avery filed another petition to stay this appeal and remand this case to the circuit court for Avery to litigate a motion for post-conviction DNA testing of bone fragments collected before trial, pursuant to Wisconsin Statute 974.07. On December 28, 2018, this court denied the petition, stating that, quote, the scope of this appeal is limited to a review of the circuit court's orders denying Avery's Wisconsin Statute 974.06 motions, unquote, and therefore, quote, good cause to remand had not been shown, unquote. This court gave Avery a further extension to February 1, 2019 to file this initial brief. On January 24, 2019, a week before his initial brief was due, Avery filed a third motion to stay this appeal and remand the case to the circuit court. This time, he sought to pursue a new claim that the state violated his due process rights by releasing a portion of potentially human bone fragments to the Halbach family for burial, roughly 5 years after Avery's trial. This court again remanded the case to the circuit court to allow Avery to pursue this additional claim. The circuit court denied it without a hearing on August 8, 2019. This appeal then finally proceeded. The briefing was concluded June 26, 2020. On November 9, 2020, the case was submitted to this court on briefs. The only step left in this appeal is a decision from this court. On April 12, 2021, long after briefing had concluded and after this case had been submitted to this court for 5 months, Avery submitted yet another motion for remand. This time he claims that a new witness, Thomas Sawinski, had come forward to post-conviction counsel on April 11, 2021. And then there's a post note that we'll get to in a second. And said that while he was delivering newspapers to the Avery Salvage Yard on November 5th, 2005, he saw Bobby, and now at the bottom of the page it says, Avery's motion says Sawinski came forward April 11th, 2021, but his affidavit is dated April 10th, 2021. Yeah, and I caught that too when I was reading it. Dassey and an unknown older man pushing a RAV4 up a hill. Did it say up a hill? Okay, sorry. I'm supposed to just be reading this, not commenting. Avery claims that Sawinski called the Manitowoc police to report this later in the day, but police were not interested in this information. I also don't recall it saying he called police. Avery claims the state suppressed this information and therefore violated Brady. He seeks remand to pursue this claim in the circuit court. Relevant law. Avery is permitted to petition the court, quote, for remand to the circuit court for action upon specific issues, unquote, pursuant to the Wisconsin statute. Not even going to bother to read the numbers. The decision to remand is left to this court's decision, and then it's citing a case law. The rules of civic procedure apply to appeals and to litigation of Wisconsin statute motions, provided that they do not conflict with any specific rules of procedure spelled out elsewhere for such actions, and the context of the rule does not manifestly require a different construction. And then citing other cases. As relevant here, Wisconsin statute, blah, blah. I know people get upset when I say blah, blah, but I'm not going to keep reading those numbers. Provides that by presenting a submission to the court, an attorney is certifying that, to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, all of the following. A. The paper is not being presented for any improper purpose, such as to harass or cause unnecessary delay or needless increase in the cost of litigation. B. The claims, defenses, and other legal contentions stated in the paper are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. C. The allegations and other factual contentions stated in the paper have evidentiary support, or, if specifically or so identified, are likely to have evidentiary support after a reasonable opportunity for further investigation of or discovery. The purpose of the statute is, quote, to place a professional obligation on the attorney as an officer of the court to satisfy, and then it's got in quotes, herself, that there are grounds for the action, defense, or motion, unquote. And then citing case law, and then a footnote that says there is a fourth prong to the Wisconsin statute, but it is related to pleading defenses and so does not apply here. Quote, the duty to conduct a reasonable inquiry mandates, unquote, that an attorney validate the facts being alleged before proceeding with a claim. And now it cites other cases. The reasonableness of an attorney's inquiry into the facts supporting an allegation is determined by considering the following factors. 1, quote, the amount of time the attorney had to investigate the claims, unquote. 2, quote, the extent to which the attorney had to rely upon his or her client for the underlying facts, unquote. 3, quote, whether the case was accepted from another attorney, unquote. And 4, quote, the complexity of the facts, unquote. This provision has intentionally been crafted to replicate Federal Rule of Civil Procedure, citing other cases, Accordingly, courts can also look to cases interpreting, and now there's a footnote on this one too that says, there is a fifth factor when assessing pleadings in civil cases, quote, whether discovery would benefit the factual record, unquote, and then citing cases. That factor is not relevant here, though, because discovery is not available in appeals nor in criminal post-conviction proceedings except in limited circumstances. Blah, blah, blah. All right, next page. That rule when applying Wisconsin statute, blah, blah. Argument. 1. Remanding this case for Avery to pursue another new constitutional claim at this late juncture would be inefficient and unduly prolong this appeal. Avery again asks this court to stay his appeal and remand his case to the circuit court so he can litigate another new Wisconsin statute 974.06 motion. The issue Avery claims he would like to pursue is an entirely new claim alleging a Brady violation based on a purported new witness who provided post-conviction counsel with an affidavit on April 10, 2021, alleging that he told law enforcement about seeing Bobby Dassey moving a car on November 5, 2005, that resembled the victim's vehicle. As before, Avery does not seek remand for fact-finding on a specific issue raised in his earlier motions. His motion is another request to pursue a new constitutional claim. Avery admits that this is a new issue that counsel purportedly discovered on April 11, 2021. This case is now in a distinctly different procedural posture than it was when this court granted Avery's previous motions for remand in the name of judicial efficiency, however. This case has been fully briefed since June 2020. It has been submitted to this court for a decision since November 9, 2020. The parties have already expended an enormous amount of time and effort on briefing this appeal. Presumably, this court has already dedicated a considerable amount of this court's scarce time and resources to addressing the issues already briefed as well. Given that this appeal is nearing its end rather than in the pre-briefing posture, it was when Avery previously sought remand, it makes more sense to conclude this proceeding and for Avery to then file a new Wisconsin statute, blah, blah, motion once this case is remitted to the circuit court. As previously noted, a Wisconsin statute, blah, blah motion, quote, may be made at any time, unquote. And if, quote, the court finds a ground for relief asserted for sufficient reason was not asserted, unquote, in a previous Wisconsin statute motion, the new motion is not subject to the procedural bar of state versus blah, blah. If Avery can establish a sufficient reason for failing to raise this claim in the motions currently under review, the claim will not be barred, and he can waive a new Wisconsin statute motion once this appeal has concluded. If he cannot establish a sufficient reason for failing to raise this claim earlier, the claim is already waived and the procedural bar already applies. It would unduly prolong these proceedings further to remand now after considerable time and effort has been expended by the parties and this court, and this appeal is nearing conclusion. This court should deny Avery's request for remand. 2. Avery did not conduct a reasonable investigation into his new Brady claim before filing this motion in violation of Wisconsin statute, blah, blah. Quote, at a minimum, the reasonable inquiry standard requires at least some affirmative investigation on the part of the signer, unquote. False swearing is a felony, Wisconsin statute, blah, blah, and Avery's attorney has an ethical duty not to present false statements to the public, the state, and the court. Avery's motion shows, however, that his attorney conducted no affirmative investigation into this claim before filing this motion for remand. Avery claims in his motion that Mr. Sawinski came forth on April 11, 2021. Avery then filed the motion at issue here on April 12, 2021, with the only factual support alleged for it an affidavit from Sawinski himself full of vague allegations. Avery's motion does not state that his attorney made any effort to substantiate this claim. His attorney did not attempt to perform an open records request with Manitowoc County to see if this conversation ever occurred or whether any record of it existed before filing this motion. She did not try to learn who this female officer Sawinski claims he spoke to might have been, or even which female officers were employed with Manitowoc at the relevant time. She apparently did not press Sawinski for any specifics about this allegation that could allow her or the state to investigate it. Indeed, Avery's attorney apparently did not perform so much as a phone call to try to back up this information before filing this motion. There is no excuse for this lack of verification. There was ample time to investigate this allegation. As explained, there is no time limit for bringing a Wisconsin statute motion, and if Avery has a sufficient reason for failing to raise this claim in his previous motions, it is not procedurally barred. If he does not, the claim is already procedurally barred, and pursuing this motion for remand is a fruitless endeavor anyway. Avery's attorney did not have to rely on Avery for the factual foundation underlying the motion. Indeed, nothing in Avery's motion suggests he is even aware of this story, let alone that he provided any facts about it. And as mentioned, there were several ways to investigate whether there are any factual underpinnings for this tale. It was not impossible to investigate such that Avery's attorney had to rely on Sawinski alone. This case did not originate with a different attorney, and post-conviction counsel has hardly made it a secret that she has been pursuing post-conviction relief on Avery's behalf for the past 6 years. And finally, while this case is complex, the allegations relayed by Sawinski and underlying the elements of a purported Brady violation are not. Quote, to perform an adequate investigation before proceeding with a claim, it is clear that an attorney may not simply rely on his or her client's word, unquote. It follows then that neither may an attorney rely simply on the word of a person like Sawinski, someone who appeared out of the blue for the first time 15 years after this case began and long after Avery's appellate brief was filed. This despite extensive media coverage of this case, particularly during the 5 years this post-conviction proceeding has been proceeding, and just fortuitously happens to provide the exact exculpatory story Avery has been seeking. Yet for some unexplained reason, he failed to provide it to Avery's attorney until now. The need for an attorney to approach such claims with skepticism and to at least conduct some type of investigation before filing an affidavit attesting to the story's veracity is particularly heightened where, as here, the attorney has offered a $100,000 reward for such information. Quote, paper filed in the best of faith, even when the lawyer is convinced of the justice of the client's cause, is sanctionable if counsel neglected to make reasonable inquiry beforehand, unquote. Quote, the investigation need not be to the point of certainty to be reasonable, unquote. Quote, nonetheless, the signer must explore readily available avenues of factual inquiry, unquote. Quote, a statement that is offered as a positive fact but is actually an extravagant inference from vague recollection does not satisfy this requirement, unquote. Avery's attorney did not conduct a reasonable inquiry into this claim. Denying remand in this situation is appropriate. 3. Avery's many remand requests have been filed for an improper purpose warranting denial of his later request. The obligations listed in Wisconsin statute are independent, meaning that the statute has been violated if any of the prongs has been violated. Avery's disregard for Wisconsin's rules of procedure and his persistent serial filings show that they have been made for improper purposes, to delay the proceedings, to continually change his position to make it difficult for the state to respond to his ever-changing or ever-shifting allegations, and to frustrate the court's ability to reasonably evaluate his claims by burying them in paper. Quote, improper purpose does not necessarily refer to bad faith or intent to harass, ... Indeed, any reckless disregard of the duty owed to the court can suffice, unquote. Avery has continually misrepresented the facts, misstated the law, and made claims grounded only in speculation with reckless disregard for their truth or falsity. Avery's conduct shows that his many filings, including this one, were filed for an improper purpose. Avery has now filed 6 motions alleging claims that could have been raised in his first Wisconsin statute motion. He has ignored and attempted to circumvent Wisconsin statute by continually labeling his successive motions, quote, supplemental, unquote, despite the fact that each of his previous motions had been denied when he filed his new ones, meaning they could not be supplements to his previous motions. Citing other cases, he has pursued diametrically opposed claims and submitted evidence that he reasonably should know cannot all be true. Accusing Strang and Buting of being ineffective for failing to establish Ryan Hilgas as the only possible third-party perpetrator, and claiming Sergeant Colburn planted the RAV4, then alleging they were ineffective for failing to establish Bobby Dassey as a possible suspect with the same evidence, and now claiming Bobby planted the RAV4. Further, Avery has inappropriately changed his arguments or raised new ones in his reply briefs, giving the state no opportunity to respond. He has buried and burdened both the circuit court and this court with thousands of pages of exhibits, many of which were unnecessarily repetitively filed multiple times, and many that were never discussed in Avery's filings. He has leveled completely unjustified accusations of bad faith against the state. And finally, he has disingenuously presented his claims to this court by affirmatively misrepresenting how and when he raised his claims below, changing his claims on appeal, adding new allegations he never presented to the circuit court, and materially misrepresenting the record. In short, Avery has engaged in a pattern of, quote, gamesmanship that offends the rules, ... and demonstrates a cavalier lack of candor with this court, unquote, and the circuit court. The state is not seeking sanctions here. Oh, gee. However, this pattern of conduct shows that Avery's belated remand request has been made for an improper purpose. This court should deny his motion. Again, if Avery no longer wishes to challenge the circuit court's decision denying the claims he raised in the Wisconsin statute motions at issue here, he may voluntarily dismiss this appeal. As noted, his new claim is mutually exclusive with some of the claims he raised previously regarding what theory of defense he believes Strang and Buting should have pursued, and cannot be squared with many of the allegations in his appellate brief. The process of winnowing out weaker appellate claims and focusing on those more likely to prevail, quote, is the hallmark of effective appellate advocacy, unquote. Alternatively, if he does not wish to give up his challenge to the circuit court's denial of issues raised in the motions at issue here, he must wait until this appeal is resolved and then determine how he wishes to proceed. But staying the appeal and remanding the case to the circuit court for fact-finding on another entirely new claim that Avery has not attempted to verify is not appropriate. Avery's request for a remand is contrary to Wisconsin statute prohibition on successive post-conviction litigation. Conclusion. The litigation of a new Wisconsin statute motion alleging a new Brady violation is not a specific issue related to the order Avery is appealing. It is a new and separate action in the circuit court. Avery has alternative courses of action that do not require further delay to this fully briefed, submitted, and 4-year stagnant appeal. This court should deny Avery's petition, dated the 16th day of April 2021. Respectfully submitted, Joshua Call, Attorney General of Wisconsin, and Lisa E.F. Comfer, Assistant Attorney General. So, we've got 23 pages in response to Kathleen's 1 page that a new witness has been found. A witness that is alleged came forward twice before and was ignored. Came forward in 2005, came forward in 2016. Ignored. And now it's come to Kathleen Zellner's attention. And so what the state wants, so Kathleen Zellner has asked for a pause in the current to bring back to the court below this new evidence. So then this new evidence can be considered with where this is paused. You have to go back down to submit this and then bring it back up to here. Instead of canceling out this and having to start all over again. Pause. Let's talk about this down here and then go back to where we were. But what the state's asking for is where it is now, we'll just let them rule. And if that ruling doesn't go your way or whatever, then start all over with this new stuff. But, and they're claiming these are things that could have come forward before. Sure, they could have if Manitowoc hadn't covered this guy up. So you can't fault Stephen or Kathleen Zellner for not knowing this guy existed. Just like you can't fault Kathleen Zellner and Stephen Avery because Manitowoc gave these bones that Ken Kratz said weren't even Teresa, that they gave them to the Halbach family. And the state knew that. Yet they had an agreement with Kathleen that they would give her these bones because she had an expert who could test these burned bones. That was a rapid test that right away would be able to identify those bones if they were Teresa Halbach or not. So Kathleen has been waiting and waiting for those bones and the RAV4. Told she would get them. Years are going by. And then you find out that they had given those bones to the Halbach family. And they knew it. Tried to cover that up. So time and time again, we're being shown that Manitowoc Sheriff's Department, Calumet County, Ken Kratz, Attorney General, all of them keep covering up evidence and not giving it to Stephen's defense. But what the state is trying to say is, well, let's not worry about any of that. This has taken such a long time, so don't even think, just because something's new, they should have brought this up before that they didn't even have. So how can they bring it up before? So, and then they're claiming that Kathleen Zellner hasn't done any investigating into this witness. We don't know what she's done or what she hasn't done. She filed a brief, or whatever you call it, because I'm not a lawyer. I'm not basically a lawyer. I don't pretend to know the law. I'm quite confused by all of this, so I'm not the one to ask on, how many days for this or that or whatever. I don't know. But to try and say that, well, this has taken long enough, we shouldn't be talking about this, but they didn't have this witness. And this isn't the only witness that we have heard from over this that saw something. They saw Stephen leave. Yeah, pay no attention to the corruption behind the curtain. Yes, I'm a Wizard of Oz fan. There are many people, I say many, there are people who, now I'm singing the Beatles in my house, in my head, sorry, who saw Stephen Avery leave the salvage yard. There are people who saw Teresa Halbach leave the salvage yard. And we have a lot of similar stories that we've heard throughout the years of being told we know who did it. And not caring to hear from this witness. And the state trying to do the, well, this has had so much coverage. Well, we here at Stephen Avery Project know every day we get people who message us saying this is the first time they've watched Making a Murderer. So they knew nothing of the case, and they've decided to watch it just now, when it came out in 2015. So how do you know this Sowinski knew of this case or whatever that he's trying to say? Oh, there's all this. You don't know what they saw and what they knew. Sowinski says when he watched Making a Murderer, he then contacted Strang and Beauty. And they didn't reach out to him. Mark Johnson, if you have any information that you think is interesting, we do love to hear it. Also recommend you send it directly to Kathleen Zellner. If it's anything that can help Stephen, telling us is great. I say this all the time that I'm so invested in this case. I, love to hear inside information, but coming to me isn't going to help Stephen. So send it on to Kathleen Zellner. You can go on her website, KathleenTZellner.com. She's got a Stephen Avery page. And on there, she has, I think it's on the left side of the page, where there's a special phone number and an email address directly for things pertaining to Stephen's case. So, and feel free to private message Stephen Avery Project, or also if there is somebody who is afraid to come forward and you want to remain anonymous, we can also be your go-between if you would like. Anything we can do to help the information get out there, or get to Kathleen, we will do. And we also, when things need to be kept private, we keep that private as well. So if so if it's something that you don't want out there at this time, there are plenty of people who are afraid to come forward because look what happens. So we can help facilitate that as well. But so the summary here, this was just the state's response that I contacted the clerk and got emailed to me, which I have to pay them for it. I have to pay 40 cents a page. And usually I have to pay for it first before they send it to me, but she sent it to me too. So I've right away gone live to now discuss all this, and so I still have to reach out and pay them, and will still pay them even though I have it already. Not going to blow that off. We'll still pay them. So this is just so this is not the court. I didn't know what I was getting. I didn't read it before I started reading it here with y'all. So I didn't know if this was court's response, but it is the state's response to Kathleen bringing up the new witness. So it's nothing we didn't expect on that one, of them trying to be, don't look at this and don't consider it, same thing they're always doing. they're saying that Kathleen didn't do enough investigation into this witness when they don't know what investigation she's done. She doesn't have to show you everything. She's saying a witness has come forward that was covered up by Manitowoc and Strang and Buting. The affidavit says he called them. Okay, so Sawinski saw this on November 5th, which is 5 days after Teresa Halbach was allegedly last seen. Okay, so early morning, November 5th, when it is still dark out, this man, Sawinski, is delivering a newspaper. He pulls onto Avery Road off of 147, turning left from 147 onto Avery Road. As he's driving up there, he sees a car, the RAV4. He said it was blue, and I know people have all this blue, it's green, blah, blah, blah. I'm telling you, I had a car that did the same thing. It was a blue car, and everybody always thought it was black. In some lights it looks blue, in some lights it looks black. When I was at the deer camp doing a live in MAM Gossip, and the Avery family reported me to the Josh Redant, and then Josh Redant called the police on me for, as Earl Avery called it, trespassing. The ticket I then received in the mail for my trespassing said it was a black vehicle, and it's not a black vehicle. My car is blue. So she's got this weird greeny color car that sometimes looks green, sometimes looks blue. But so, because I know people are dismissing this witness for saying it's blue and they're saying it's green. And I just totally get a car can look one color in one light and another color in the other. So he says before dawn on November 5th, a Saturday, he's pulling up and he sees this car being pushed. And there's Bobby Dassey on the driver's side, and then there's somebody else on the passenger side, outside of the car, not in the car, pushing the car. He then drives around them, continues to go forward. Avery Road, when you turn off of 147, will either go straight down into the salvage yard that they call the pit, or you turn right, and to the right is where either right away you would turn left from there, where is the salvage office, and then across the parking lot from that is Dolores's trailer, or then all the way down that road is where Barb's trailer and Steven's trailer is. And so I'm sure what the paper delivery person, I don't want to call him a paper boy because he's a man, does the same thing like the school bus would do. Because so the mailboxes are here, you turn right and the mailboxes are here. And then over this way is where you turn into the offices. So he would stop at the mailbox and then turn into the office. And that also goes, you can get out behind on the other side of the office, get you back to Avery Road, the straight shot back to 147. So I'm sure that's what the bus driver would do too, because the bus driver would drop the boys off at the mailboxes, not all the way down the quarter mile or whatever it is, down by the trailers, and it's a big bus. It's not going to back up and all that. So I'm sure the bus did the same thing. So as that guy turns around and now is going straight back down 147, so now he's on the driver's side, Bobby's on the driver's side, he's passing that way. He sees Bobby. Bobby takes a step over, trying to block him from leaving. And he drove off into what he called a ditch. And I know some of the Avery family who are trying to discredit this witness will say there's no ditch. What is just meant by it is Avery Road's a gravel road, and then there's grass to the side, so you can drive. So drove on the grass and the dirt that's alongside the gravel road to get around Bobby, who was trying to stop him. So then the search party happens that day where Pam of God goes to the office, gets permission from Earl Avery to search the salvage yard without a search warrant, and she's able to find the car within 20 minutes, where I've walked that path twice now, and there is no way she can find the car that fast without being told where to go. Then it's in the news. This guy sees it in the news, and so he contacts Manitowoc to say that he saw Bobby Dassey pushing that car. Because when he saw it in the morning, maybe he's not thinking how weird that is, that somebody's pushed, and he says he knows it's Bobby Dassey. So when he's seeing it, maybe he's not thinking it's weird that Bobby Dassey is pushing a disabled car to the salvage yard. But then when he sees on the news that this missing girl's car has been found and what the car is, and I'm sure this is something he remembers because he's saying Bobby scared him, that the look in his eyes and stepping out, so he remembered that. So he contacts Manitowoc, to which he is then told, we already know who did it. He leaves his contact information, nobody reaches back to him. We don't know what happens from 2005 to 2015 when Making a Murderer comes out. But he says when he sees Making a Murderer, he then reaches out to Strang and Buting to say what he saw, and nobody got back to him. So this person has twice tried to tell what he knows, and nobody does anything with it. We do not know when he reached out to Kathleen Zellner. We know when the affidavit is dated. I see people asking for a copy of the state's response. It's something that was emailed to me, so I don't have it readily available to post for y'all to read. I've got to send it to somebody because I'm not technical like that, so I don't know how to get these 23 pages posted. I don't know how to upload it somewhere and blah blah blah. So I'll have to have somebody else do that. So, but that's what today's filing is, or Friday's filing is, that I read today, is just thank you, admin, for handling John. So this is just the state's response to Kathleen's filing of the new witness. So now we'll hear Kathleen's response. Don't know how long it'll be till we hear Kathleen's response. And then I don't know how long it'll be till we hear from that court. Don't know. I never know for sure what if there is a set limit, because sometimes there is. You always hear there's a 30-day or a 60-day or a 90-day. So I don't know. If any of y'all out there watching are real lawyers, not pretend lawyers, and you know how long it is, please let us know. So, and as soon as there is any other response, whether it's Kathleen's or the state or whatever, we go live as soon as we get it and read it with all y'all. So you all get it first. Like I said, I hadn't even read it. I got it and I was like, oh my God, and real quick trying to go live, to bring it to you right away. So what I'm probably going to do now is we have our closed group, MAM Gossip. That's where we discuss things a little more in depth. So I'll end this live because this Stephen Avery project, this is our public page, for anybody anywhere to see. You don't even have to like this page to follow it and see the information we put out there. But closed group, you have to be a member, and we don't have quite the troll situation, even though there are trolls that hide and watch. Always going to watch what we do, right? So we'll end this now. Go live in MAM Gossip, where I'll read this all over again in there, and we'll discuss. And as soon as anything else comes out, we'll bring it to you as soon as we get it. Thank you, everybody, for your continued support of Stephen and Brendan. We 100% here believe in Stephen and Brendan's innocence, and we're here till the end, just like Kathleen Zellner will be with Stephen until she gets him free. And that, unfortunately, it takes a long time to free somebody who's wrongfully convicted. So, all right, everybody. Yeah, wave to the trolls. And investigation continues. See all of you over in MAM Gossip who are going to join.